Good evening and welcome to Africa News Network First Fast Live. My name is Cindy Mabi. Thanks indeed for joining us. Now, on Monday, the South Gauteng High Court said the law limiting sexual offence cases to a statute of limitation of 20 years must be scrapped. The ruling means both children and adults must be allowed to lay charges at any time after sexual offences occurred. 8 alleged victims of the late stockbroker Sidney Frankel won their case to change the legislation. The group of victims have an ongoing civil case against the Frankel estate. They've accused Frankel of assaulting them as children. Although Frankel died in April, he has many supporters, and the 8 are pursuing civil claims for damages. The judgment means that sexual offences have the same effect on victims as rape cases. Now, this judgment must first go through the Constitutional Court for approval. The court could make minor changes, and then the National Assembly has 18 months to change the Criminal Procedures Act. Let's take a look at this landmark ruling on sexual assault made by Acting Judge Claire Hatford in the South Gauteng High Court. The ruling says allegations of sexual assault can be pursued at any time and are no longer restricted to a 20-year time limit. Both children and adults must be allowed to lay charges at any time after offences occurred. And the current law on sexual assault says Section 18 of the Criminal Procedures Act imposes a prescription period of 20 years in which to prosecute a sexual offence other than rape. And the judge's reasons as to why the ruling was made. Firstly, Acting Judge Claire Hatford agreed the 20-year cut-off on sexual assault cases denied victims their rights to justice, dignity and equality and was unconstitutional. And victims of sexual assault offences dating back more than 20 years might now feel encouraged to report their cases. And joining us live in studio is Sheena Swema, researcher for the Center for Applied Legal Studies. We have Dr. Shahida Omar, clinical director for the Teddy Bear Clinic. She joins us via Skype. And Ian Levitt is the attorney for representing the victims, and he's on the phone line. Lula Manare is a commissioner for the Commission of Gender Equality. Good evening to you, ladies, and thanks so much for joining us. We'll start in studio. It is indeed a landmark ruling that the judge has made. But in terms of prosecution and the chances there of considering the time lapse, Sheena, what do we have to consider for victims who want to come forward even after the 20-year limit?
Well, in terms of the procedure or the way prosecutions are currently being handled and the rate of convictions for sexual assault cases and rape cases, the delayed period does have an effect on the outcome of the case. So currently we have very low conviction rates for rape cases and sexual assault cases, and those could have occurred a year ago. So now when we have something that occurred 20 years ago, the evidence becomes problematic.
But I mean, in terms of fighting gender violence, and I suppose for justice and dignity of rape and assault victims, for them to be encouraged to come forward, do you think this is a step in allowing people, albeit the time lapse, to come forward, Lula?
To us, it's a landmark ruling because it takes into consideration the whole issue of patriarchy. And it also takes into consideration the issues of culture, the issues of financial dependency of the victim towards the person, the vulnerability of when you can lodge actually the cases. So it's a landmark ruling that deals, in a big way with patriarchy itself.
Let's invite attorney for, or rather representing the victims, Ian Levitt. Thank you so much for your time. In fact, I mean, for the victims, I suppose this would be some sort of comfort that justice indeed will be done. But in terms of preserving the evidence and also...
Sorry, you're not coming through clearly.
Yes, can you hear me now? Hi, Ian, can you hear me? All right, we're going to have to patch you again. We'll go to Dr. Shahida Omar, clinical director at the Teddy Bear Clinic. Good evening to you, and thanks so much for joining us. Just your initial reaction to this landmark ruling and what it means to victims of assault and rape.
Hello?
Hi, can you hear me, Dr. Omar?
Can you hear me?
Yes, we can hear you loud and clear.
Okay, so what it means to victims of sexual assault, firstly, it acknowledges their abuse, it recognizes them, and it validates them. So they feel that they've been listened to, they've been heard, and that it will encourage other victims to come forward and make disclosures, because disclosure, as we realize, is very complicated. It's a lengthy process, and it takes some victims a lifetime to come forward and make a disclosure.
And just testing the validity or veracity of the disclosure as well, especially if the perpetrator may not be alive to defend himself. What happens in that case? Will they then go after the estate of the perpetrator?
Well, I'm not qualified to respond to whether they could go after the estate, but I think the important thing from our angle or from the clinic's perspective is that the victim is given a free trial or access to justice, that their rights are acknowledged, and that they are given access to the criminal justice system, something which the statute of limitations denied them. It was discriminatory and it violated their rights to human dignity. So I think this is definitely a major feat, a major victory for all victims of sexual assault, and not only applicable to children, but to adults, which includes men and women, and the fact that it is now including all sexual offenses, because the statute of limitations, no statute of limitations, only applied to the crime of rape, whereas this is a broad relief, and it's going to encourage people to come out of the closets because they know they will be recognized, heard, and that there will be measures instituted.
All right, Dr. Omar, please stay on the line. We have Ian Levitt. He's the attorney representing the victims. I hope you can hear us clearer now. And now, of course, this matter rests with the National Assembly in augmenting or changing the Criminal Procedures Act, especially when it comes to the definition of sexual offences, that being punishable and equal to rape. What is your reaction to this move?
Well, what is my reaction to the judgment, or
Correct.
what is
Yes.
Okay, so my reaction to the judgment is that it makes huge inroads into the ability to facilitate a successful prosecution. I heard one of the other guests there, perhaps I was wrong because the feed was not good, state that that something about a 1 year and a 5 year and an 18 year and a 25 year. It has nothing to do with the issue of a good case and a bad case. The question is that the Director of Prosecutions, the National Prosecuting Authority, should always have a discretion when there is a good case, when there is good evidence. So, for example, it's not necessarily true that after 20 years the evidence is worse, because there could have been photographic evidence. The father could have molested sexually abused his child when the child was 6 months old. The child wouldn't even remember it, but at the age of 22 finds a photograph in the side table drawer, and the father can laugh at the now adult. If there is, after 1 year, after 1 day, after 6 months, after 23 years, good evidence, then there should be a prosecution, and it should be no difference between 19 years and 364 days and 20 years and 1 day when there is good evidence. A prosecution should take place. It takes a momentous amount of courage for somebody to be able to prosecute somebody who has betrayed them, especially in terms of this type of crime. It's normally a close family member. It could be a brother, it could be a father, it could be a mother, it could be a mother's best friend, it could be a long-lasting employer of a parent. It could be something that a parent is still employed by the employer after 30 years, and that could have also been one of the reasons. If the evidence is good, the person should be prosecuted and be called to account.
Now, we understand, based on statistics, that the majority of contact crimes happen with people that are intimate or are known to the victim. What happens in the case where the perpetrator is deceased? Will the precedent of the Frankel case also come into play in that the victims can now pursue their legal or their litigation through the estate?
So the litigation against the estate had nothing to do with this judgment. This constitutional issue had to do with the prosecution of Frankel. Frankel, having passed away, makes the prosecution of Frankel impossible now. But my clients launched the application knowing that he was apparently ill. That was what the attorney for Frankel said several years ago. But what they did was they launched the application not only in their private legal interest, but in the public interest. So in order that if Frankel did pass away, the case could continue, and this affects criminal prosecutions. The civil cases still carry on against these states. It's commenced 2.5 years ago, and it will continue against Frankel's estate.
All right, please stay on the line, Mr. Levitt. We also have Sheena Swimmer, researcher for the Center for Applied Legal Studies in studio, and Lula Manare, Commissioner Commission of the Gender Equality Commissioner. And just looking at some of the frivolous cases, and I'm even loath to have to mention that, women, the burden of proof always rests with the victim, but there may be odd cases where there have been frivolous claims made against an alleged perpetrator. How then does this judgment affect that possibility?
Well, generally, I'd like to state that there had been a study by the Medical Research Council, and when you say frivolous cases, this can be as low as 2%. So ordinarily, we're not dealing with frivolous cases that do come forward. If, however, you're speaking about perhaps the delayed period of coming forward for this, and perhaps that was then created, this seldom happens. It's because the trauma that is created and the trauma that these individuals live with, it's extremely difficult for them to come forward. So it's almost a tiny percentage that would be frivolous in this. But when the case does go to trial, so the actual case, this is saying prosecutors are allowed to prosecute cases that come after 20 years. And the evidence will then be weighed up in trial. The prosecutor will decide, is the evidence strong enough? So I don't think there is any kind of danger of frivolity in these types of cases.
Yeah, or any abuse of it.
Yes.
But in terms of victim empowerment as well, especially where the crime transcends from childhood to adulthood, what kind of support is there? Again, I imagine that it's not an easy thing to want to disclose or to share, let alone to go to report to strangers in a police station. So what kind of support is there?
I think for me there is support, but as a country we are having an outcry that we're not doing enough. We have not legislated these support services. We have not put more funding to make sure that they exist. And probably the police, although they have been trained, they continue to put their own prejudice against the victims and doing secondary rape. And I think as a Gender Commission, why we think this is a landmark case, it opens up the opportunity for gender activists, women's rights groupings to kind of talk quite comprehensively about gender violence. And I think the limitation itself was putting, that acknowledgement that this has rape, sexual assault has a long-term effect on the victim itself.
And Dr. Omar, I mean, we've just seen in recent months the high level of femicide and the brutality by which women are treated, mutilated, killed, burnt, and let alone the child abuse that we have. I think South Africa is also regarded as the highest rape capital, I guess, in the world. What does this ruling then say in at least the judicial system, their attempt to try and remedy what we're facing at the moment?
Well, I think if we look at this limitation being removed, as I've mentioned earlier, that this is going to motivate and give impetus to people to come forward because previously they were not in a position to do so. Now they will be more empowered to come forward. As our learned colleague Ian Levitt described so aptly, it takes a lot of bravery and courage because often victims feel like the perpetrators. They feel they are to be blamed for what has happened. They often suffer from the damaged goods syndrome, where they feel they are unworthy, they are bad, they are ugly, they are dirty, and therefore do not come forward. And it takes sometimes a lifetime, as we saw in these 8 victims who came forward. But coming back to what you spoke about, the horrific statistics, we know that 1 in 4 cases are reported, and in 1 in 9 cases of sexual abuse or rape get convicted. So this will certainly, if more people come forward, knowing that we have 57 sexual offenses in the country, this may increase the strain on the criminal justice system, on the judiciary, and I think this is something that's going to require urgent attention when Parliament fixes this piece of legislation. So yes, I think this is a challenging situation. It is a landmark victory, but we also need to commend the bravery of these 8 applicants that came forward after the fact.
All right, Mr. Levitt, and indeed, the bravery, we commend the victims that have come forward, but, you know, it's not a one-size-fits-all or a prescribed method of how to encourage other victims to come forward, because this is a singular trauma that only that person bears, and we can't live it for them. So in encouraging victims that may feel, look, it's buried now in their psyche and they just simply want to move on, what would you say?
I would like to say to any victim that or survivor that is out there the following. When the applicants or my clients first came to me, they expressed, I sat with them around, I sat with various of them around the table, and I sat with others, many others in this Frankel case, who had the same allegations against Frankel, who weren't able to put their name down to paper, but came to give them verbal encouragement in their case. And I understand, and I had spent tens or hundreds of hours with various people here, and so has my firm. What I'm trying to make is that I acknowledge the difficulty that they are experiencing, and we can all sit here as experts and say how nice it is now, but I can tell you that it is extremely difficult. There's a lot of victims out there who say, lovely, so thanks for the judgment, and they go back home in their pain. Their lives are absolutely damaged. They're beyond how anybody can even understand this. I have given a personal view to this, that this is like a murder. It's really like a murder. The perpetrator has asked for this child's trust, has given their ultimate trust. He then betrayed them by molesting them, and the effect of this trauma has changed their lives from what they were on the trajectory that they were going to a completely new damaged trajectory. And it's a murder of their original soul, of their original tracks in life. No money will ever compensate what they're going through, but what will help is to be able to look that person in the eye, in the witness box, and know that they are going to be punished. No child of 6 has the capacity to consent to any touching or molestation or rape or anything. They don't have the capacity to consent to it. So I would encourage them that there is a degree of help that and in the victory of seeing the perpetrator going to jail. I say, please come forward. There are people that will help you. There are many more people that will help you than you will ever believe.
All right, thanks so much, Ian Levitt. He is the attorney representing the victims. Dr. Shahida Omar, clinical director with the Teddy Bear Clinic. We'll continue and wrap it up here in studio. We talk about various ways of coming out and support and to have, I suppose, that courage somehow to reach out to somebody and tell about your trauma. But in most cases, as you were saying, that the conviction rates are not as successful. That still needs to be revisited. So how else, if you don't go the legal route in reporting of sexual offences, can people get help?
Well, the Centre for Applied Legal Studies actually acted on behalf of the Teddy Bear Foundation in this matter. And the Teddy Bear Foundation is a perfect place for children who have suffered some kind of sexual violation to go, and they offer psychosocial support. So it's not necessarily focused only on the litigation or the criminal matter. The Teddy Bear Clinic is a fundamental part of helping children deal with this trauma. And I would suggest reaching out to the Teddy Bear Clinic.
Yeah, and can you as a sibling or next of kin report a matter on behalf of a survivor who may not feel they have the strength or even the aptitude to want to report the case?
I think as a Gender Commission, we do take cases of anonymity and we do follow them up with the discreetness that is deserved. We even go with victims to court. We do the court monitoring. We interact with the magistrates when we are not satisfied with the conduct inside the court itself. And I think that the services are free as well.
Yeah, I mean, we often bring up this question about being desensitized because of the sheer brutality that we read on a day-to-day basis. Have we just become numb, where it just becomes numbers, and as and when a story develops, it makes headlines?
I mean, I do think at this point it is numbers and it is desensitizing. And I think cases such as this with the Levenstein matter, we are sensitized again. Yeah. We see the pain, the trauma that these individuals have had to endure for so many years, and this reminds us that these people are human and that they aren't just a number. So these cases are very important not only for the legal precedent that they set, but humanizing or rehumanizing these types of matters.
All right, we'll put your contact details on our website and on our social media platforms. Ladies, thanks again for joining us. That's Sheena Swimmer. She's a researcher for the Center for Applied Legal Studies, and Dr. Shahira Omar, Clinical Director at the Teddy Bear Clinic, Ian Levitt, attorney representing the victims, and Lulama Nare, Commissioner for Commission of Gender Equality. Thanks again for staying with ANN7. We're back after this.